Welcome LML 4807 students to this online lecture. This lecture involves lesson 6 of your study guide, and we shall discuss the nature of a deposit and the legal position of leaving valuables with a bank for safekeeping. I will start with a quick mention of what you have learnt in lesson 5. You should remember from the lecture in lesson 5 that the bank-customer relationship is based on contract and it is multifaceted, as it involves various types of contracts depending on the nature of the service that the bank offers to its customer. So for purposes of lesson 6, we will be discussing the contract of deposit, known as Depositum, and safekeeping. Please do keep in mind, when we refer to the contract of deposit or Depositum in this lesson, you are not to get confused with the term deposit as defined in the Banks Act 94 of 1990, as they are not the same concepts. We dealt with this term as defined in the Banks Act in Lesson 3. The definition of deposit was discussed in light of determining what the definition of a business of a bank is in terms of the Banks Act. To be able to understand the definition of a business of a bank, you had to first understand the definition of deposit, as the word deposit appears in the definition of a business of a bank. Please look at the online lecture on Lesson 3 again if you are uncertain as to the definition of deposit as in the Banks Act. Today we will be discussing Depositum and safekeeping. Depositum is a contract in terms of which one person, the depositor, delivers an object to another, the depository, who keeps it in his custody without using it and with the obligation to return the same object to the depositor. The development of Depositum originated from the giving of valuables to a goldsmith to store. In 1640, Charles I unilaterally appropriated a large amount of money that the wealthy stored in the Tower of London, a place where they used to store their surplus gold and valuables. This event caused the wealthy to rather store their valuables with goldsmiths, as they had safe custody facilities where they used to store their own gold in. Goldsmiths were also considered to be reliable merchants, and those who entrusted their surplus to goldsmiths could withdraw it whenever it was needed. Goldsmiths played an important role in the development of modern banking, as the wealthy stored their surplus gold and valuables, and goldsmiths realized that only a small part of the total amount deposited was reclaimed at a time. They could then lend the balance at an interest to other merchants in need of capital. It is from this era that the term deposit is derived. The giving of valuables to a goldsmith resulted in a depositum, which is a contract of deposit. When the relationship changed so that the goldsmiths obtained the right to use the money or gold given to him for his own purposes, coupled with the obligation to return the same amount or mass to his customer, the nature of the contract changed from one of depositum to one of mutuum, which is loan or consumption. So, in spite of this change in the nature of the contract, the name deposit remained in use. So deposits taken by banks today do not involve depositum as a form of contract, but are now treated as mutuum. Please see part 1 of lesson 5, which fully explains what is meant by the concept of mutuum. Today, in modern banking practice, a customer may still leave his or her valuables with a bank for safe custody, but the contract rather provides for safekeeping instead of depositum. This concept will be discussed on the next slide. We will now look at safekeeping and a bank's liability regarding a safekeeping agreement. In modern banking day practice, where a bank provides a safety deposit box for the use of its customer, the relationship is rather regulated by a rental agreement. The bank rents out the safety deposit box for the use of its customer. The terms of the rental agreement are usually contained in a standard printed contract. This contract will normally prohibit the customer from lodging certain items with the bank for safekeeping, such as illegal items, weapons, and other dangerous property. The bank is not liable as a depository for the safety of such valuables because the legal relationship between the parties is governed by a rental agreement. The customer personally deposits his or her valuables, and when they are required, they remove them from the rented locker, which expressly excludes the bank's liability for loss and damage. A customer may have exclusive access to the box and control over its contents, as the customer would have the key to access the box. The bank is unaware of the contents of the box. The terms of the agreement also usually include a clause to require the customer to insure the contents of the safety deposit box. The purpose of the clause is that the risk of loss or damage of the contents of the box is that of the customer. A standard agreement will invariably contain a clause excluding the bank's liability for loss or damage arising in various circumstances. However, a safekeeping agreement between a bank and a customer will be subject to the Consumer Protection Act 68 of 2008, which came into general effect on the 31st of March 2011. The CPA advances consumer rights by regulating the activities of suppliers and creates rights for consumers. The CPA would be applicable to a safekeeping agreement as, in this particular context, a bank is considered a supplier and a customer of a bank is considered to be a consumer in terms of Section 1. The safekeeping agreement is for the supply of services as required by Section 5 of the CPA. Consumer rights are protected by the CPA. Among others, it includes the right to a fair and honest dealing and the right to fair, just, and reasonable terms and conditions, and also the right to fair value, good quality, and safety. It is still to be seen what a court's interpretation of the CPA in the context of safety deposit boxes would be, specifically in light of the right to fair, just, and reasonable contract terms and conditions, and whether a court will come to a different conclusion as that reflected in current South African case law. We will now consider case law relevant to safety deposit boxes. We will discuss Minsky versus Absa Bank and First National Bank versus Rosenblum. Please note we will briefly discuss the cases today, but you are to please study the case law carefully and in more detail. These cases form part of your prescribed reading material. In Minsky versus Absa Bank, the client and the bank had concluded a written agreement in terms of which the plaintiff had rented a safety deposit locker at one of the bank's branches. In terms of the agreement, the bank had undertaken to exercise reasonable care for the security of the locker area. More specifically, the contract determined that the client himself shall be responsible to ensure the contents of the locker. The client deposited jewelry and foreign currency in the locker, and sometime after the plaintiff had deposited the jewelry and the currency, the locker was misplaced by the defendant when it was relocated to a different premises. In this case, the court reasoned that the provision of the safety deposit locker was not a profitable business for the defendant bank. It further pointed out that the bank provided the facility at a modest fee, and it was not entitled to know what the client was placing in the locker. The bank had notified the client of the fact that it had moved the safety deposit blockers to a new premises, and further had informed the client that unless she took some available action, the agreement to continue to store the client's possessions at the second branch would cease. The agreement having been terminated, the bank became obliged to return the client's possessions to her, but it could only do so if the client came into the branch with her key to the locker, which she did not do. The court concluded that given her lackadaisical or careless approach, the client could hardly complain that the safe with her locker had to be removed. Ultimately, the court decided that the bank had acted reasonably in the present circumstances and that the client's claim had to be dismissed with costs. In F&B versus Rosenblum, Rosenblum had leased a safety deposit box from the bank. The contents of the box were subsequently stolen, and Rosenblum sued the bank. It was argued by Rosenblum that the bank's liability stemmed from the theft of the box by its employees and/or from the negligence of the bank's employees. The contract between the parties exempted the bank from liability in the event of a range of occurrences, including theft and negligence. The bank sought to avoid liability by relying upon an exemption from liability clause contained in the lease agreement entered into with Rosenblum. The court quo rejected the bank's defense. The SCA found that both theft and negligence were stipulated events in the exemption clause. However, Rosenblum argued that the clause did not cover all types of theft, and that theft or negligence by the bank's employees acting within the course and scope of their employment was not covered. Pointing out that the bank had to be held vicariously responsible for the wrongdoings of its employees acting within the course and scope of their employment, Rosenblum relied on the principle that no one may contract out of liability for deliberately committed dishonest acts. This argument was rejected by the court. It pointed out that the exemption clause was clearly intended to exclude liability, even for acts which were within the bank's control. The court concluded that the bank, as an artificial non-human entity, was incapable of being negligent itself, and therefore, when the bank stipulated that it would not be liable under the wording of the clause that stated whether the loss or damage is due to the bank's negligence or not, the clause included loss or damage due to the negligence of its employees. The court held that the clause also covered acts of gross negligence. The appeal was upheld with costs. These cases have confirmed the principles of the bank's liability regarding its responsibility for the contents of a safety deposit box. As mentioned earlier, it is still to be seen what a court's interpretation of the Consumer Protection Act in context of safety deposit boxes would be in light of the right to fair, just, and reasonable contract terms and conditions. It is to be seen whether a court would come to a different conclusion as what is found in current South African case law. We will now discuss case law involving the concept of depositum. So, as already mentioned, when goldsmiths obtain the right to use the money or gold given to them by their customers for their purposes, coupled with the obligation to return the same amount or mass to their customers, the nature of the contract changed from one of depositum to one of mutuum, which is loan for consumption. Likewise, banks make use of deposits today, so a deposit made at a bank does not involve depositum, but rather mutuum. Mutuum is a loan for use, and the bank becomes the owner of the money deposited, and the customer has a claim against the bank for a similar amount on demand. We will briefly discuss the case of Transitional Local Council of Randfontein versus Absa Bank. This case provided the interesting scenario where the same set of facts, as well as the same amount of money, involved both mutuum and depositum. The facts in Transitional Local Council of Randfontein versus Absa Bank were as follows. The plaintiff was a local authority and, until 1998, conducted its banking affairs through the bank, a commercial bank. The council and the bank had an arrangement in terms of which the bank would send an employee, who I'd refer to as the teller, to the council's premises to count and verify checks and cash intended to be deposited by the council into its account with the bank. On the 29th of December 1995, this was done as usual. The teller issued, stamped, and initialed deposit slips in respect of the amount tendered for the deposit. She then put the cash into a bag, sealed it, and placed it in a safe on the council's premises. She took the checks with her. The bag had to be collected by a cash-in-transit security for conveyance to the bank. Within half an hour after the teller had placed the money in the safe, it was stolen from the safe. The council insisted that its account with the bank had to be credited with the amount of the stolen money. The bank denied that the money was ever handed over to it, that it was thus never deposited with it, and argued that the loss of the money was for the account of the council. The bank argued that the council had actually later accepted liability for the loss by substituting the lost cash portion of the deposit with a check drawn on its account at the bank. The bank raised a counterclaim in that the council had a duty of care to safeguard the money while it remained on its premises. Put differently, the bank argued that the contract of depositum came into existence between them, in terms of which it deposited the bag containing the money with the bank. In terms of this contract of depositum, the council was liable for custody of the bag. The bank further argued that the council had breached this duty because it did not prevent the loss of the bag. The legal issue that arose for decision was whether the bank, through the actions of its teller on the council's premises, actually took possession of the money, thereby completing the deposit made by the council. The court held that the conduct by the teller constituted the taking of a deposit by the bank and that ownership of the money passed to the bank. The court accordingly held that the money had been deposited by the council with the bank and that the latter had to reflect this in their books. With regard to the bank's counterclaim, the court noted that it was common cause that the parties were engaged in a contract of depositum. One of the legal ramifications of a contract of depositum is that once it was proved that there was such a contract and that the deposit had been lost, the onus was on the depository, the council, to prove that this had occurred despite due diligence on its part. In this regard, the court pointed out that the issue of onus of proof was significantly affected by the question whether the claim was couched in delictual or contractual terms. The essential difference was that in delict, the council had to plead and prove that it suffered the loss. That is, that it was the owner of the goods or bore the risk of loss or damage or destruction concerning those goods. And the bank lost or destroyed the goods due to fault on the bank's part. The court then proceeded to make a factual evaluation of the facts before it and accepted that in the present case, the claim was couched in delictual terms. The bank therefore had to prove that the money was lost as a result of the council's negligence. After a careful analysis of the concept of negligence as applied to contracts of deposit and the test for negligence in such circumstances, the court confirmed that the test to decide whether the council acted negligently was an objective one. It further confirmed that the actions and omissions of the council had to be weighed against those of a reasonable person in the same circumstances. The court decided that the council did not breach its duties under the contract of deposit, and the counterclaim of the bank was accordingly dismissed with costs. The bank was ordered to pay the council the sum of the stolen money plus interest. This case provided the interesting scenario where the same set of facts involved both mutuum and depositum. When the bank teller counted and accepted the money, this constituted mutuum. When the teller handed the money back to the local council for safekeeping, this constituted depositum. This concludes for our lesson today. I hope that you have a deep understanding of the concepts of depositum and safekeeping.